I think we may start. Good afternoon, everybody. Let me introduce myself. I am Linas Sesickas, practicing attorney at law, member of the bar. And the reason why the organizers invited me to moderate this session is that in 2007 I was working as the legal consultant of the Open Society Foundation and also of the Open Society Justice Initiative based in Budapest. And I was actually coordinating the project which aimed at the reform of the state guaranteed legal aid system in Lithuania. And the project was implemented by the Open Society Institute together with the Lithuanian Bar Association and the Ministry of Justice. So I think that both these stakeholders, they were very important throughout the entire process in identifying all deficiencies or shortcomings of our legal aid system at that point of time. And I think that as a result of that fruitful cooperation, Lithuania was the country which adopted the full-fledged state guaranteed legal aid system at that point of the time. And I still strongly believe that in spite of the fact that I know that there are certain deficiencies in our current system and there are lots of areas that could be addressed and improved, that Lithuania still has one of the most advanced state guaranteed legal aid systems throughout the entire region of the Central and Eastern Europe. And I also realized that this is very unique opportunity not only for Lithuania but also for other member states of the European Union to discuss all the issues and problems related to state guaranteed legal aid and in particular to state guaranteed legal aid quality. Since the directive was adopted last year and all member states are in the process of implementation of the directive. But at the same time, I think that all these issues that are of particular or crucial importance to member states and to the bar associations and to law societies is the quality of legal aid that we are providing to those who are in need of. And I also acknowledge that there are different models which exist throughout the world, and we could discuss about all these pros and cons and compare those models and question them. But I think that this is the very good direction that was chosen by all member states, that we have the systems in place, better or worse, but they are in place. So what is really very important that we would ensure that the systems provide the best possible quality and they really create the value for the money that I invested. So in this afternoon session, I think that we will be able to discuss in more details and in greater focus what kind of quality standards could be set up. We already heard the presentations from those countries who are, in my view, the most advanced. It's UK, Netherlands, other countries. We also heard the experiences shared by some countries which are already in the process of developing the new systems, like Ukraine. So I think that as a result of today's session, perhaps there could be some kind of list of proposals prepared, what kind of minimum quality standards could be developed, taking into account those best countries, best practices of other countries. What kind of control mechanisms or administrative procedures could be implemented in those countries in which do not exist yet, and taking into account what is, in my view, very important, the balance of interests of the state or the government to ensure the transparency and accountability of the public funds. But on the other hand, what is very important to ensure the independence of the bar and the professionals, the legal advisors or members of the bar, because it's very important that those who are real or genuine service providers, that they would feel that they are not controlled too much by the government, and that they really do the best that they could do. So before starting the discussion, I would like that everybody from our panel just would introduce shortly themselves. In particular, this request is addressed to those who did not have this opportunity. So, and then to stand up or raise the hand, that we would know who is who, and that those persons are those who will be contributing to our session. So, first person in the list is Vaida Rubenita. Okay, perhaps you could say some words about yourself, what you're doing in the ministry, and what challenges you are facing, and what issues are important to you.
My name is Vaida Rubenita. Nice to see you all here. And here I work with the issues of legal aid and with the cooperation with the bar and coordination of legal services provided by advocates. Regarding our today's topic, the quality of legal aid, we have certain aspects of quality control. We have the entry requirements, we have the trainings, continuous trainings, and also we have the individual control of the complaint control. If the person complains, his complaint is forwarded to the bar, and the bar has the rules for the control of the advocate. Also, we have agreements which are concluded by the legal aid service with the lawyer who provides legal aid. And legal aid service has certain rights to control under those agreements advocates who provide legal aid. Furthermore, the agreements have an exemplary list of model requirements which an advocate has to follow. So if an advocate doesn't follow them, the legal aid service has certain rights to address those issues. However, well, certain aspects of quality control are there, but we definitely need something to strengthen our possible ways to help the quality, to help the effectiveness, and well, everything what has been said yesterday and today, well, it will help us to have a discussion with the bar, with other stakeholders, and to address this issue, and to help us to have a more effective, efficient, and really high quality system. So that would be it for the beginning.
Thank you. The second person which I have on my list is Herman Schilperud, manager of Legal Aid Board Netherlands. So I think that there is no need for you to introduce yourself because you already did this. So the third person is Maria Builu, deputy head of the Department of Judicial Administration, head of Legal Aid and Enforcement Unit, Ministry of Justice of Finland.
Yes, and you already mentioned my position, but I could perhaps add to that these days have been very useful and given a lot of food for thought for the future, since we are in charge of strategic operations on field of legal aid, and as we heard on Kirta's presentation, we are working on the subject of quality. But there are a lot of, I think when we talk about the criteria, I think this morning was very giving already, so I think we also already saw very concrete examples for the criteria. And if I think of how to improve them in legislation, in Finland we only refer to code of conduct of the bar, and that's how we have built. We have built on those principles our criteria in our client survey. But there are many ideas to go on. One question that I would like to ask for discussions, or bring for discussions, when we piloted our system and we made this client survey, what came out of it was this client survey and self-evaluation. But in the pilot phase, we also had a peer review, and you mentioned that we decided not to go on with that. It seemed quite a lot of input for an expensive system, so we dropped that for now on. But we also did have a questionnaire for judges and for prosecutors. And now, during these days, I've been thinking, might that be something the other stakeholders? So that's an open question which I will bear in mind, and I'm interested on your points of view.
Okay, thank you. And Yelena Barbara, head of the Legal Aid Provision Division, Deputy Director of the Legal Aid Administration of the Republic of Latvia, our neighbor.
Hello, dear colleagues. I'm very proud to participate in this conference, and I agree with my colleague from Finland that the theme about concrete criteria in order how to create the quality, how to improve this system. And in some words, about our institution, Legal Aid Administration is responsible for providing legal aid in civil and administrative matters, and we are an institution who pays out funds for legal aid providers in criminal proceedings. In criminal proceedings, police, prosecutors, or court granted legal aid, and our institution is only responsible for financing. About quality criteria, which is in our system now, we have disciplinary responsibility also in advocacy law. In contract which are signed with us in civil and administrative matters, we have concrete criteria, for example, compliance from persons. We are analyzing this compliance. We analyze also results from the case, but we are doing only each 100 case, for example. And then in criminal proceedings we have exclusive competence for attorneys, and that is why we want to closer cooperation with the Bar Association. And these criteria we want to draw in our law, because today we have only internal rules of advocacy. These rules are not from our side of government, but only internal for authorities themselves. And that is why we cannot control if they are not so good in practice.
Thank you. And let me introduce Ivanka Ivanova, Open Society Institute Sofia. I have to say that we know each other more than 15 years. It happened so that I was working, as I said, for Open Society Institute, so Ivanka is my old colleague.
Indeed, I'm Bulgarian. I'm working for a non-government organization, and I've been involved in the reform of the Bulgarian legal aid system since 2001. Currently, we are leading partner together with the National Legal Aid Board in Bulgaria in a project whose aims and activities are rather similar to the one that has gathered us together for those 2 days. Initially, with our project, we have started with an overview of the guarantees and systems to monitor quality of legal aid in several EU member states. It's not comprehensive. It only covers 6 EU member states. On the second stage of this project, we are doing a rather comprehensive quantitative study we are going to review all the cases for legal aid provided in the pretrial case of criminal investigations in Bulgaria in 2015, take a representative sample of those in order to be able to establish a baseline for the profile of the advocate, the profile of the client, basic demographic statistics, and a description of what they normally do in those cases that are already paid by the National Legal Aid Board. At the end of the project, we expect to be able to develop non-obligatory standards for the behavior of the legal aid lawyers who appear in the pretrial phase of criminal investigations. And later on throughout the process I can describe how we decided to go about it, about its content and the methodology for developing those. Thank you very much.
Thank you. William Vinkar, Directeur de Greffe, Tribunal de Grande Instance de Reuil, France. Sorry for my French, but...
Good afternoon, ladies and gentlemen. So my name is William Winker. I'm basically a court manager, and I'm vice president of my legal aid board. So a few figures. In France, we have 160 regional courts, and in each court, we have a legal aid board. President of the legal aid board is a magistrate, and vice president are court managers. We are dealing with 1 million applications a year, and our state, France, spends 500 million euro a year for legal aid. So basically, in the legal aid board, we decide if people they can be granted with legal aid regarding to means test. We have only a few merit tests, but mainly means test. As a preamble, I would like to say that maybe we should consider quality of legal aid not only from the point of view of evaluation of lawyers, legal aid providers, but also with quality of legal aid boards, because I don't know for your country, but in France, for instance, when you want to be granted with legal aid, you have to go to a regional court, ask for legal aid, and it depends on the legal aid boards. It can you can have a decision within 10 days or 10 months to be granted with legal aid, especially in civil cases, but it can be the same for criminal cases. So we have a special indicators for legal aid boards, and we are supposed to give a decision within 30 days. For instance, my court, it's more like 60 days than 30 days. So there is a red alert in the Ministry of Justice, and they are looking on the legal aid boards we have that have bad results. So quality of legal aid is not only a matter of legal aid, quality of legal aid providers, but I mean we have to look inside our structure to if we are good or bad. And I will intervene later, but about criteria, France is not as good as Finland or Netherlands, I guess, or Ukraine, but basically bad quality is about complaints that we complaints towards lawyers that we can receive.
Thank you. And just to add on your comment, that I also fully agree that when we talk about the legal aid quality standards, it's not only about the lawyers, it's about their full system, whether it functions or not. And the reasons why the system do not function, there might be a number of reasons. And one of the reasons that you mentioned is actually the speediness or efficiency of the administrative decisions taken to grant or not to grant, or eligibility determinations procedures. And I also know that, for example, when we discussed this issue of improving the legal equality standards in Lithuania, that our lawyers are a bit uncertain whether this, so to say, process and result of that process, the standards themselves, whether they will afford and be able to implement them, given the fact that at the moment they face a number of difficulties in delivering the legal aid. So I think that there should be always very complex view at the issues that we're discussing, because if we raise the requirements for the lawyers, there should be also there will be certain implications. They will need to spend perhaps more time, and there should be more money channeled to the system. And if the system itself lacks certain funding, so I think it might be even difficult, to achieve what we're aiming to achieve. But we will be able to discuss all these issues a little bit later. So then, Alexei Bonyuk, I think that you introduced yourself, unless you want to comment something at this particular point of time.
Thinking about and talking about the standards of legal aid, it's easier for Ukraine because we have one implemented in our legislation. And now we are thinking about the institutions that could be engaged in the assessment of these standards. And we think that we can combine the role of our existing system of quality managers is some kind of internal monitoring of quality and the external monitoring, so-called peer review, because we haven't this kind of auditing or monitoring legal aid in Ukraine. And I think that we can use the combination of work of our legal aid institution, of our legal aid quality managers and external bar association, because it could provide us with the peer review. And I think that it could give us good results.
Okay, thank you. And the last speaker on my list, but of course not the least, is Dr. Livio Alexandru Lascu, the military prosecutor's office and the military tribunal. Good.
Thank you. First of all, I want to tell you, you don't have to believe everything I tell you, because I'm a prosecutor on the other side, and we, maybe we don't need to have a very good defense. Okay, I'm joking. Don't believe me again. It's a serious problem, legal aid provided by the state. And what concerning our system in Romania, after 2 days of presentation, I realized it's not very different than the most of the European countries. Therefore, I don't want to give so many details about it, and only discuss about how to improve the quality of this legal aid. Unfortunately, in my country, there is no a system of evaluating, assessing the legal aid provided by the state. And this is not good, but like a professional, I can tell you this is to a very low quality. And as I told you, even though it's not our interest to have a very good defense, it's very important for a fair process. So basically, this is a job for a young lawyer at the entry level, and they have no motivation, not enough knowledge, and therefore their performance is not very good. And it's not good also for us, for the prosecutor or the judge. Why? Because having a good defense, you can be more focused on our activity. And in this way, to avoid some mistakes. Or sometimes, if you have no defense or a good defense, you have to do the work of the lawyer, yeah, to explain to the accused what are the rights, the possibilities, the situation of him within the process. And therefore, I think it's very important to have a good quality in the legal aid. So, in what concerning the system of evaluation, there is not in Romania such system, but I think the question have to take care of. It's very difficult. It's very difficult to make objectively an assessment because each of the criminal case has its own circumstances, and to put one together with other, I think it's a mistake. What is very important in my view is to have a minimum standard, to oblige the lawyer to have contact with the accused, to inform him about what is the situation of the accused, and many other things which can be very well established from the beginning, and the lawyer to follow them with these rules. The evaluation is also a problem because we don't know who is entitled to do it. Because in the market of this legal service, who is the evaluator? The client. In the private situation, private relation with his lawyer, the client, he evaluates how good, how bad is the lawyer. In this case, when the legal aid is provided by the state, who have to be the evaluator? I think it's always the person who pays. This is normal to be so. So in our case, if the legal aid is paid by the state, I think the best solution is the state to have, I don't know, an organism, an institution making it, not the bar. The bar is not interested in doing the evaluation because the money is not coming from the bar, for the service. It's from the government. The government or the Ministry of Justice, I think, who do this job. And this job is very important. Unfortunately, we have no such instrument or legal instrument to check to evaluate the legal aid. But I would propose this if somebody asks me. The state, the government, the Ministry of Justice would do it. And beside of this evaluation, I think the minimum standard is very important to be regulated. Thank you very much.
Thank you. I think you raised a number of very important questions that we will be able to discuss later on for other subjects. But the questions that you raised, they are directly related to the question who should really take part in the development of the quality legal aid standards. Should be those standards developed by the government? Should be those standards developed by the national bar associations? Should they be developed together? If yes, so on what kind of the legal basis they should be developed? Should it be included in our national laws, or should it be regulated by the certain decisions of the national bar associations or bar councils? Or should it be some kind of memorandum of understanding signed between the legal aid boards or legal aid services and the bar associations? Perhaps the participants could elaborate a little bit on this particular question that I raised. Yes, please. I think that you have the mic.
Yes, I think that's a good question, and it's quite self-evident that the administrator should be involved because they are paying the whole thing, and of course the providers as well, because they are the actors and they know the profession. But I would like to then raise, how about the beneficiaries, the clients? They don't know the legislation perhaps so well, and there's always a debate that you can't ask the clients because they wouldn't know the law and they just know the result. But I would ask, doesn't it matter, perhaps at least to ask what they want actually, and there might be some good points on the client perspective.
I fully agree with you that in this system of the evaluation of the quality of legal aid, there should be some kind of client satisfaction or survey component to that, and we definitely need to ensure the certain feedback from the side of the client. Because what is really very important for all of us, those who are working within the system, is to get the real feedback from the person who received the legal aid, or in a way even the public service. Do we have some comment? Yes, please.
Of course, you should pay attention to the judgment of clients, like we do with client surveys. A lot of people think that a client can't judge the quality of his lawyer. I think he can judge some things. You know, he can judge if his lawyer is really working for him, if he pays attention to the question, if he's really interested. You can judge whether the lawyer explains things in a clear way to him, if he can play a role in the decision-making process. These are all things that clients can judge, of course. They should be able to give a comment, at least, about their experience with the system, like we do. Better judgment on the work of lawyers can be done by prosecutors and also by judges. It's like you said, Maria. You can also give them a role. We opened a few years ago a web address for lawyers, and they can make comments, you know, on the behavior of lawyers that provide subsidized legal aid to clients. Also, we gave the prosecution service the opportunity to make comments. It's important that you do this. In our country, the deans play an important role. The deans of the local bar associations, they have talks with the prosecution service, with the head of the prosecution service in their region, and also with the president of the court each 2 months. And one of the items is always, are some lawyers misbehaving? So the courts and prosecution service can inform the dean. Also, we give feedback to the deans about what we see in the behavior of lawyers filling in their requests or filling in their declarations. And in our country, the Bar Association is willing to play its role, but it has to play its role because assisting clients before the courts is the prerogative of the bar. But it's always a question, should this only be the prerogative of lawyers, or are other professionals as capable as lawyers are? So when it is a prerogative of the bar to assist people before the court, the Bar Association has to play a serious role. And we see in the last, I think, 5 years, that these play a much bigger role than they did before. They're not waiting. If they get signals, they can visit the law firm, you know, and start to ask questions. You have a periodical audit. So every office is visited once in 5 years in the Netherlands. But if there seem to be problems, they easily can walk in. And so the Bar Association can play a role, should play a role, and if they don't, it's, I think, the role of the Ministry of Justice to ask questions about this. This is my opinion.
intervene. My name is Vilnius Law Institute of Lithuania, and my research field is trust in criminal justice institutions. And when we speak about considering the opinion of persons who use legal aid, well, we can speak that we are not professional. We can estimate it in a professional way how good the legal service was, but, well, the opinion still matters. And an example of this is, in my opinion, how many people call the police in certain situations. And this number, how many crimes are reported, it's very related with trust the police, how effectively they're dealing with crime, how often they solve the cases. And if we look at this system of legal aid, then also the same question can be raised. If people will not trust legal aid system just because they feel bad about how service was provided, so they will not apply for the help. So the whole system loses its point. So that's the idea.
Yeah, well, so I think that you raised a very, very good point that, I mean, after all, I mean, the system is designed not for itself, it's designed for actually for people to receive the legal aid and to receive timely and to receive at the moment then he or she is in the most need of receiving this legal aid, because I think that when it comes to the criminal process, it is clear that when a person is detained, the police person is that, I mean, that this should be the moment when he or she should be offered a lawyer or the member of the bar. And then when we in the last session we get the findings from this UK research that not all of the cases that people ask for lawyers, and the reasons why they are not asking for lawyers, they again might be very different, including the fact that people are not familiar with the fact that they can get a lawyer, or they're afraid of getting the lawyer, or they think that the lawyer might be somehow related with the police officers working there. And that is exactly the system that we got 20 years ago. The lawyers, some lawyers, they've been even called as the pocket lawyers, or lawyers of the law enforcement officials or the judges. They're good friends of them, and that you can really trust the lawyer who will help you. So I think that this is very, very good point that you raised. Ivanka, you wanted to comment on.
I just wanted to highlight the point that was made by Marianne, later on by Herman, about the importance of bringing the judges into the process of evaluating the quality of legal aid. The Bulgarian legislation contained a certain ambiguity regarding the quality of legal aid. On one hand, the responsibility for monitoring the quality is split between the Legal Aid Bureau, that is the managing organ of the system, that is executing the payments, and the local bar councils that are actually assigning the individual lawyer to the specific case. So the first ambiguity is that the law says both of them have responsibility when it comes to quality, to monitoring the quality of the legal aid. The second ambiguity is that our law uses the term quality, but also uses the term competent provision of the service. When the Legal Aid Bureau or the local bar council establish that there is incompetent provision of the service, there are certain consequences that can be derived both from the Legal Aid Act, that is a separate legislation in Bulgaria, and the general law that is regulating the practice.
So I'm still trying to figure out, but for those countries who are advanced, I mean, they already took the decisions, and I think that it took a number of years for them to take the decisions, and perhaps still a bit uncertain whether those decisions that they took are the best decisions, but I mean, they've been already taken. For Lithuania, I think we're still discussing about the question whether there should be this minimum quality standards established, and who should really establish them, and how you could really ensure that those standards are followed. One of the instruments is peer review, but as we had, it worked in Netherlands for a while, but right now, I mean, it's not regulated, so I mean, there is no any possibility how could you really ensure this? And could it really be a solution, say, in other countries who are not so much advanced as Lithuania is? Perhaps you would like to, okay?
No, I don't want to agree.
Okay. No, it's okay. I think that, you just need a mic, I think.
Well, because with our project we have already decided that we want to have standards, especially in particular when it comes to the provision of legal aid in the pre-trial phase of criminal proceedings. Probably I can explain what type of logic we have followed. First, by saying that we want to have standards, we say that we want to have something that is not obligatory for everybody to follow. We admit that it is up to the individual situation and individual decision of the counsel and his client to decide what is the strategy in a specific case. And we cannot impose on them what the strategy should be. So by preparing the standards, we are preparing something that in advance we say is not going to be obligatory for everybody. We wanted something like a soft law that we want to be used for threefold purposes. The first purpose is to help us educate the client and to explain to the client what he can expect from a good performing lawyer. So we want in this standard to be capable to tell the client, if you are paying for your lawyer by your own money, and if you are receiving a very decent quality service, the lawyer should do A, B, C, D. So this is the first purpose. The second purpose of those standards is to use them in the training of the lawyers that are going to specialize in particular for provision of legal aid in the pre-trial phase of criminal defense. Recently, the Bulgarian Legal Aid Bureau has increased the minimal requirement for in-service training from 5 hours annually for the legal aid lawyers to 20 hours annually, which is to a visit to our partners from the Netherlands. So within those 20 hours, they have to provide a training, and they have to have a training material based on which they have to explain to the lawyers what a good lawyer normally does. So this is the second purpose. And the third purpose is that according to our system, the local bar councils and the National Legal Aid Bureau can decide on the final amount of the payment that is due on every particular case based on the number of activities that the lawyer has performed in those cases. However, they have never had an exhaustive list of all the good things that a lawyer can do in specific types of case. And that's why we want those standards to be there for the people in the local bar council and the National Legal Aid Bureau to know that if the legal representation is guaranteed to a maximum high degree, it should include this number of activities. So you can expect from a lawyer to deliver an activity that is out of this list, and the more activities from this list he or she delivers, the better the performance of the lawyer is going to be assessed, and the higher remuneration he can expect. Of course, this is within certain fixing the law limits. I mean, they cannot increase incredibly lot his remunerations, but they have certain margin of appreciations, and we want this margin of appreciation to be based on objective criteria rather than to be based just on the decision of somebody in the legal aid board. So This is our understanding of what standards should be. In developing the standards, we recruited a lawyer who has the renown of a very good criminal defense lawyer, and we have asked her to review together with us all the cases for legal aid in pre-trial phase of criminal proceedings that were provided in Bulgaria for 2015. We reviewed a representative sample. And based on what she sees in those files, we asked her to draw a list of the activities that she would typically do, that she sees that the lawyers do as a good practice, and that she would think it is going to be recommendable to do on a systematic basis, not individual original actions, not to include them. We have reviewed the literature. It turned out that in '91, actually, a very prominent Bulgarian criminal defense lawyer has published a small booklet that was dedicated to the clients. And in this booklet, he has explained on each stage of the preliminary phase of the criminal proceedings what a good lawyer should do. So we were pretty much using as a basis this writing, but because it was '91, it was prior to the accession of Bulgaria to the European Convention of Human Rights. That happens the next year. So now we are explicitly requiring the lawyer who does it for us to include relevant reference to the current practice of the European Court in Strasbourg. Once we are ready with the draft, and by the way we are, we think that this has to be adopted through a very thorough consultative procedure that involves the professionals in the criminal justice system, policemen and prosecutors who have the right to appoint the counsel, judges, representatives of the bar, and representatives of the Legal Aid Bureau. I think these stakeholders have to be involved in the process of consultation alongside this document. What is very likely to happen is that we are not going to agree on the content of the full document. So we have decided to publish something that is called Legal Aid Standards, that is going to be used for the understanding of the client, what he can expect, and it's not going to be obligatory in any form. And on that basis, the Legal Aid Board is going to take out only the minimum amount of activities that have to be performed and adopt them probably through a methodological guidance or something, because they have the right to issue methodological guidance for the practicing lawyers. This is our approach. Regarding the content, from what we heard these 1.5 days, we see that most of the systems do work with proxies. They don't address neither the outcome of the case, neither the specific legal strategy of the legal specialist in the case. They evaluate other things, and they said, this is good enough for us to say that the quality is good. And I believe that this assumption is correct. If the lawyer was on time, if the lawyer fulfilled correctly the documents that he needs in order to submit his plea to the Legal Aid Bureau for payment, if he was correct in his attitudes towards the other participants in the criminal justice procedure, if he was polite to the client, if he explained well to the client his rights and so on, we can assume that this lawyer is also a good lawyer and he made reasonable choices. And yet, it is not the real thing. That's why we structured the document differently. We structured the document along the most common activities that a client can be involved with in the criminal justice procedure in the pretrial phase. He can be interrogated, he may be detained in deprivation of liberty for certain periods of time. He may be asked to participate in different activities to carry on the investigation. And for each one of them, we have asked the lawyer to describe what he typically thinks that has to be done, and based on the review of the documents, what he sees that his colleagues do, and he thinks that this is a good thing to do. Thank you very much.
Thank you for your very exhaustive comment, and I think that I can add from my side that when we talk about this the quality performance standards, I just recall that when I was visiting the public defender office in New York, they established in Harlem district, public defender offices, they're just handling the criminal ex officio cases and also the cases for those who are in need of. But for those lawyers who are actually full-time employees of the public defender offices, they have so-called criminal case tracking system, which is actually, yes, I mean, you introduce the personal data of the client or the suspect or the person who is actually in need of the legal aid, and then actually you have a list of activities that could be done within that particular process. And even the standard written applications and forms, they're like created like a templates, which if you introduce this personal data, basically the system itself generates automatically these, so to say, applications for requests for something. So I think that this is the way, and that was 15 years ago. I've seen this in New York, so I believe that at least in those public defender offices, they are established not only in the US, in the UK as some kind of pilot projects, in Israel, in South Africa. This is the way how you could really make sure that at least this minimum quality performance is really ensured. And I think that this is the idea that could be really discussed in member states of the European Union while developing the minimum legal aid standards in those countries where they're not existent yet, or in those countries which are in the process of developing the standards. So I would like also ask representatives of other countries just to comment on the question, do you have these minimum legal aid standards in your jurisdictions? Those who already answered to this question, so we know that you have, but those who did not have opportunity to comment, I would gladly ask you to do this. France?
No, actually we don't. We don't have. But, I would like to make two remarks. The first one, about people getting afraid of asking for a lawyer if this one is bad, for example. In criminal proceedings in France, lawyer is not mandatory. But if you don't have a lawyer, you cannot have access to your file. So people always ask for legal aid to have access to verify. And the second one, about institution. In our legal aid boards, we got so the president or vice president, which is a representative of the Ministry of Justice. We have a representative of Bar Association. We have a representative of bailiff for enforcement of decisions. And we also have a representative of Consumer Association. And I think that, but we don't go further. This legal aid board is only to grant people with legal aid. But I guess that we could assess legal aid providers with this kind of legal aid structure because we got representative of all parties. Oh, sorry, I forgot. And we have one representative of Ministry of Finance. Because, as you said earlier, when the payer, it must or should assess people that are getting paid. So we have a representative of Ministry of Finance. And we got all these representatives, and I think this is a good picture of society, and it could be helpful to assess legal aid providers. But sorry for your questions. We don't have minimum standards.
But how does your bar association use, if there is, I mean, a number of complaints that lawyers do not perform their work and that, you know, that the system itself does not function, you know, orderly or well, so there should be some kind of, you know, tension in the air that something should be done and the bar should take a responsibility or should take an active role in reforming the system.
There is a chart. There is the president of the Bar Association who have disciplinary proceedings, and we could have some suspensions, but this is not strictly linked with legal aid. It could be for a private client too. So there is, in France, there is no distinction between legal aid and private activity. But the Bar Association, President of the Bar Association, with its board, can suspend or exclude a lawyer. That's for sure.
Romania?
Yeah, thank you. First of all, I realize we have many things in common with the French legislator, not randomly. we know why. In what regarding the minimum standard, as I told you before, there's not such standards in Romania, but most probably the legislator will take some steps because the question of quality of legal aid is a problem, a very big problem, and the system currently exists is not enough for having a control over the situation, because like in France we have a disciplinary procedure for the lawyer, and it works, but not in this direction. I mean, it's not about the quality of the performance, it's about other things, like, I don't know, breaching the rule of the bar, the ethics, the ontology, something like that, or breaching the criminal law, but not about the quality. This is very important, this other thing. I told you before, the state would be in the first position to ask the lawyer to have, I don't know, very well conduct in their performance because he paid. But maybe I was not enough clear. It doesn't mean only the state, but by its representative, have to contribute to making some rule in such problem like minimum standard and the assessment of legal aid, because it's very important to be ask the bar associations. It's very important they know professionally how are the I know the demarches of the lawyer with the criminal procedure, and I want to say as many entities involved in this process, as good result will be. What can I do now is just to propose, to propose the factors who decide in this aspect. I'm just a person involved in this legal system. I'm not a legislator, but it's very good the information I received to this conference. Honestly, it was the first time when I discussed about this topic and realized how important is this issue in most of the countries. And I see, like you, the system in UK and Poland very, very good. And I'd like to disseminate this experience to my colleagues and to the destined partners in Romania. Thank you very much.
Thank you, and perhaps participants from Finland and Latvia could also comment on this particular. Oh, okay, sorry. Okay.
Sorry for interrupting. I just want to ask one question to our French colleague because I'm not sure if I understood it correctly. You said that if you have no legal representation, you have no access to your files in criminal procedures. And my question is, if I'm rich and I can afford a private legal representation, and I know that I can afford it, but for example, I don't have it and I don't want to pay for it. Can I ask for the free legal aid just to get access to those files? Like, I don't understand the idea how it is possible. But
No, you can't because you don't pass the means test. If you're rich enough to afford a very good lawyer, the best lawyer of the bar, you cannot be granted with legal aid because you are above the threshold of the mini test.
okay, but then I have to pay for it to have access to my files?
You don't have to pay to access your file. You have to pay to have a lawyer, and this lawyer, only the lawyer for criminal proceedings can have a look on the file.
How is this constitutional, really?
This is
This is like, for me, it is really something strange because you have a right, like in Poland, you have a right to access to every single file that's about you, and you don't need the representation for it. If I want to defend myself in court, I can do it. This is the access to information.
anyway.
I'm surprised, really.
Anyway, if you are poor, you can have legal aid and then a lawyer and then access to your file via your lawyer. And
But
if you are
through another person.
sure, definitely.
This is the violation of my right to privacy.
Really?
I'm sorry, I'm so surprised.
It's a discriminatory treatment of those who have means.
Actually,
That's true.
this is constitutional in France, and I would say that we know some law clerks in office, they don't trust every lawyers, and even when they give the file to a lawyer, some of them they look at the lawyer to be sure that this one he won't get away with a piece of the file. Yes, it's a matter of security. But poor or rich, you can have a lawyer and then access to your file for criminal proceedings. That's not the case for civil proceedings.
Thank you for clarification. Mary, would you like to comment on the question that I
I have a lot of thoughts again, but first I'd like to. I pretty much liked your reasoning for the minimum standards to bring it up that the beneficiaries or clients are able to see the standards and understand what they can expect. I think that's a very good point. And also the point of training of lawyers who are getting into. So it's very open to anybody and easy to fulfill if wanted. But that brings then to another point. I think the Ukrainian, I liked your presentation very much, and I think it was a good simplification or good way to put it, that there are two things that you need to make good quality and when delivering legal aid, and one point is, or what are the kind of like safeguards for that. So one is training so that the ones who are giving legal aid know what they are doing and how to act. But the other one, and not lesser at all, is the moderation, which we also referred to yesterday's discussions. So I'm interested in how you measure motivation, or how do you work with that?
It's in our country it's not so hard because the salary for lawyers in legal aid is maybe equal for the market. It's very pretty, but our legal aid lawyers are not motivated enough That's the answer to the question, but the salary is very small. It's of course not for country, not for the capital. For regions, it is the situation that I described. About minimal standards, I think that it wouldn't be working without any control, and if it wouldn't be implemented to the legislation. If it be only non-obligatory, it's maybe method for training, but not for controlling the legal aid quality. So it's our experience, and we think that the standards we have, it's not enough. We should have maybe another mechanism, another methods to control these standards and to make assessment of using it. And it's maybe a little problem now for us. And we are going to solve it with our bar association to examine cases, to take a look at the real work of attorneys, because without bar we cannot do this. It's prohibited, and it's the right of professional secrecy of lawyers. Of course, it's a right of privacy of every person, and legal aid couldn't do this without one. And it's our maybe vectors of nearest steps.
I just a question that just really responded to what you just said. Is your bar active in the reform? Is it responsive? Is it cooperative? Because sometimes when the Ministry of Justice or the government initiates the reform and the bar is not initially involved and is not really a full-fledged partner, that there is a lot of skepticism and resistance from the bar that it's the government which does something which was not agreed with the bar, and that it infringes the independence of the legal profession.
As a head of legal aid system, I can say that we have a cooperation with National Bar Association. And we are going to organize this process of controlling legal aid quality standards and to improve our management system of legal aid quality standards. That's why we have a problem with this whole bar association.
Elena, yes, you would like to answer to the question that I raised earlier.
Thank you. I agree with Alexei and Ivanka that these quality standards should be stated in laws. Because, as I said previously, we have such quality standards in our legal aid contracts for civil and litigated cases, but these terms are very open and not so concrete. And in criminal proceedings, we have only internal rules for attorneys, and I agree with you that customers don't know what is the rules, how to control if there is a problem with the quality in the concrete case.
Thank you. Yes, please.
May I suggest something about minimum standard? We haven't talked about. This is about fame. In France, we have 60,000 lawyers and 160 bars. The smallest bar is about 30 lawyers, and the biggest bar in Paris is 18,000 lawyers. So, if you are a bad lawyer dealing with legal aid or not, in the smallest bar, you will be very soon not well known but bad known. And on the contrary, on the opposite, we have very, very famous lawyers which are very rich, and they continue to take legal aid cases in criminal proceeding, for criminal case, because of the fame that brings to them. And they are very famous. They are well known for driving Ferrari just in front, just before the court, and they are dealing with legal aid cases. So fame is very important in small bar, and we have a lot of small bar, under 200 lawyers, and people in cities, they know, especially in criminal proceedings. That's not true for civil cases, but in criminal proceedings, a lot of people know that this one is a good lawyer, and they can take and they can ask them if they want to represent them with legal aid or not.
Would you assign this particular lawyer if a client requires? Well, the question is, would you appoint this particular famous lawyer if the client wants him?
Legally possible?
Because I understand your
Yeah.
point. I mean, we have interviewed a number of people, and there was one gentleman who told me, listen, there is only one guarantee for quality, and this is to leave the client to choose the lawyer and to serve the choice of the client. However, it's not that simple. Are you going to be capable to secure this famous lawyer?
One figure. 16% of lawyers in France, 16% deal with 84% of legal aid cases. 16% represent 84% of legal aid cases. It means that lawyers, you can choose your lawyer if you want, but the lawyer he can refuse the case with legal aid. Question?
Yeah, I have actually just based on what you just said, I have the question to all participants, whether in your systems or in your jurisdictions, has the client the right to choose a lawyer, or it just, the case is referred by the legal aid service or legal aid board? How does it function?
Well, I would have a direct comment on this claim question, but I can answer at the same time. In Finland, the client really had a free choice in all the criminal cases, so he can choose any lawyer, and if the lawyer is willing and has time, so that's his lawyers then for legal aid. So there's no question about that. But I just can't help mentioning, I agree that fame is very important in that sense that in small areas, I think that's a good guarantee of quality, because the word spreads and the good lawyers are appreciated. But the fame, there may be sides. Well, if some remember yesterday when we had the prosecutor's opinion, we also on the bench were a little bit smiling for ourselves, because it's one of the most famous lawyers who is always in publicity with the yellow pages, and he's very famous with as a criminal lawyer, and that's a bit sad because he's not the best in colleagues' criteria or judges' criteria or prosecutors' criteria. So that's complex, and there may be different aspects.
Would you like to?
In the Netherlands, there's no obligation to take part in the system. So what you see that lawyers that are working for companies and so on, they don't take part. They don't have anything in the business of individual persons, the persons that apply for legal aid. But in the criminal area, we have quite a lot of very good lawyers working in the system because you can't see by the eyes if a criminal is entitled for legal aid or not. You know, it depends on his financial situation. The information that's provided by the tax office. But a lot of good lawyers work in the system, and also clients can ask, can I be assisted by this lawyer? And of course he has the opportunity to refuse to accept a client. But there are very famous lawyers, and there are lawyers that are not famous. You need all of them, I think, to have a good system.
But Herman, just a bit to clarify on this particular issue. Suppose I'm determined by the legal aid board that I'm entitled to receive the free legal aid. How does it really function? How, I mean, the case is assigned to a lawyer. Is it automatical? It's a list. Do I have a right to choose, or how? I mean, how do you manage the entire process as the legal aid board?
You can find our list on the internet, on our website, which lawyers can assist you on a certain matter, family case or criminal case. You can go to the service counters, they have the same information. If you're taken from the street and you need legal aid before police interrogation, you can ask for a lawyer that you know, and we will send an email to this lawyer if he wants to accept the case of the client. If he refuses, we will ask another one. That's how it's worked, but you always have free choice of a lawyer. You can also go to a law firm and ask a lawyer to assist you, and you can apply for legal aid. So there's a lot of possibilities. As I said, 7,000.
So it's like maximum flexibility allowed. You can basically choose any. Do you have a list of lawyers who are providing this free legal aid, or there is a special list, or basically?
You can find it on our website.
I would also like, because I just was about to ask the question for our actually Ministry of Justice and the Bar, I know that the Bar Association representative is not here, so we have the representative of the Ministry of Justice. Is it really possible to set up some kind of legal aid standards and then could create some kind of mechanism that could be agreed between the Ministry of Justice and the Bar to ensure the quality of legal aid?
I think yes. The short answer would be, but it's a matter of discussion, and it should be thorough. We should sit down and think of common criteria, common views, and as I mentioned before, there are some exemplary lists of actions which should be done by a legal aid lawyer. He has to appear in the court, he has to give advice to his client, he has to make everything to help him. So there is certain actions which should be taken. But, well, the Ministry of Justice believes that we can go further, but we need the agreement from the bar to make that. But, well, it is possible, but we need to discuss it, we need to find the common ground.
Because the reason why I asked this question, when I was working with the project, it was I think 2003 or 2004, when I say we, at that point in time I was representing the Open Society Foundation, we organized the workshop on minimum legal aid quality standards in criminal cases. And I remember that at that point in time, even though I'm practicing law, a member of the bar, I received a lot of resistance from the bar side by saying that, you can't really define any kind of the standards because the cases are different. how can you really make sure that, I mean, each lawyer has to be professional, so the mere fact that the lawyer is the member of the bar automatically ensures that the certain performance standards or quality standards are ensured. But I see that, I mean, discussion that we had, it was almost 13 or 14 years ago, so we are still, I mean, in the same situation where the standards are not developed here, and there is still discussion whether they should be in place, what kind of standards, and then also related question is who should really do this monitoring in, in individual cases where the particular lawyer is, performing according to the standards, because I think that there should be some kind of peer review element enshrined in the system. But these are the questions that are not really easy, and I think that the bar is very important partner in this process.
Yes, definitely, and well, it's a disappointment that we do not have Lithuanian bar representative with us to discuss it. According to the laws which are in place right now, the only subject who can perform the control is the Lithuanian bar. If we talk about the quality control, that's only the Lithuanian bar who has that ability, possibility, which is enshrined in the law. So, no other possibilities to do that currently.
And this quality review, is it possible that in the long term, once the standards are established and certain control mechanisms or whatever, supervision mechanisms are created, that the government would fund this kind of activities? I understand that you are not the person who can answer this question, but in principle, in my view, this is very important that sometimes that all these decisions are made and if legislative changes are in place, that there should be sufficient funding allocated. Otherwise, I mean, you can really discredit the very idea, which might be very good.
Yeah, I could not agree more. Funding is the key issue. Well, the Ministry of Finance is always on top of that. And of course, if we initiate some changes, major changes, some quality control system, which we intend to do, we have to find funding for that, for it to be effective and efficient. So yes, that's the question. The funding is definitely an issue.
I wonder whether you can answer to this question, but at least representatives of those countries where these minimum standards, so to say, exist, and there are some kind of quality assurance procedures and mechanisms in place. How much funding is allocated to ensure fulfillment of this function? Do you know the figures? Or is it possible to? Do you have this funding available?
We invest in the peer review system for asylum and alien cases about 200 euros yearly, which is not much. And to have all those best practice guide written, we invested, I think, about 300,000 euros, which isn't that much either, because we spent each year 450 million euros on legal aid. So you should make some reservations for these kind of measures. And to roll out a system of peer review over all cases, it would cost perhaps 2.5 million euros, which is much more money. And this money is not there at the moment. But we did something, and at least we got some good experiences. And also without peer review, still best practice guides can play a role, in the system, also in the judgment of complaints of lawyers for the disciplinary courts, they can play a role. And also, as an example for lawyers, how they can handle their cases. This is also a thing you have to take into account. Peer review is quite expensive, but to provide lawyers with good information, how they best can handle cases, it wouldn't cost that much money. So So it's a question of funding. Indeed, what you said, that there is a big basket of things you could do, and also simple systems that don't cost that much money to open possibilities for prosecutors and judges to make comments on the behavior of lawyers. It's a complete basket, and you have to choose what's best for your situation.
But of course funding is very important, but sometimes, I mean, all these issues are interrelated, because if you go to the Ministry of Finance for additional funds, the Ministry of Finance could say, or politicians could say that, look, I mean, the service that you are providing is of low quality or bad quality. So in a way, these things are interrelated, and I was just having a lunch with Laurina's Birshow, who was actually moderating yesterday's session and discussing that in principle it's the interest to have the standards, it's the common interest. It's the interest of the bar, it's the interest of the lawyers, it's the interest of Ministry of Justice, first of all, and it's also the interest of the legal itself. Why? It's because, I mean, in a way, you have to justify your existence and to justify the funds that are already allocated and spent on the system. And if you want to actually to get the extra funding, you need to offer something to even to members of parliament or politicians, because you need to advocate for this and say that, look, if the standards are in place, if there is this, so to say, peer review procedure or mechanism or whatever, quality assurance principles in practice, they're functioning, there could be different models for this, but you then can come to the politicians and say, for the systems, if we want to have really quality service, I mean, we need more money. Because if the politicians would vote for allocating more money for legal service which is of bad quality, which does not really meet the minimum standards, then, I mean, there is no reason to do this. So in a way, this is all participants or players of that system has an interest to sell it.
Yeah, of course you need money, but also you can win some money by getting rid of stupid and lazy lawyers. That makes sense. So efficiency. If you have a more efficient working system, the whole society will benefit, especially the clients, but also other participants in the judicial area, like the prosecution service, the police, and would you like to comment?
Yes, I would also comment about the question of the costs, but I would start a half step from there. We do have the mixed model, and a little bit referring to discussions of working with the lawyers or the bar, since we have the mixed model, that even both in criminal and civil cases there are state legal aid offices providing services, and then there are private lawyers. It's much easier to work with the in-house lawyers, legal aid offices. We have a result management system with them, and there's a management, we train managers, and that's a way to influence. Of course, not in the single cases. The lawyers are independent. The state or Ministry of Justice can guide how to perform the case. And if there's a disciplinary matter, it's the bar that is considering that. But in, for example, as we heard in UK's presentation, so that it matters how you manage a law firm, and that's a way to influence the lawyer's motivation and actions. And so it's easier to influence the legal aid office's performance than private bar. And the other point is that we provide training for the legal aid offices, so we spend about 100,000 euros per year for training, also training the managers, but training the lawyers in many aspects. And then to the best practices, that's part of the managing and discussing and collecting. But it's much more harder. We have quite good negotiation and relationship with the bar. So Minister of Justice, we meet them few times a year and discuss matters, but also the bar is, it's independent law offices, so the bar, okay, they can have opinion and we can agree, but they are not, it's not an organization that to manage the system, so they, even the bars means are restricted. So that's one point. But yeah, there was part of the answer about the question of the expenses we spent on the quality. So that's the training. You could quite that's to guarantee the quality. But then about we presented our clients and satisfactory questions and the other questionnaire for lawyers. Well, we very intensively worked with the members of the bar to create them because they are based on the code of conduct. But they were kind enough to take part of the work without a fee, and so we worked. It was me and Kirta from the Ministry of Justice, so it paid our time quite intensively. But of course, we had other duties meanwhile, and then we didn't even make a separate calculation. We are constantly improving our data system, and that's one part of the data system, not very demanding part to create the system. So that's quite, it's not expensive at all to collect the feedback from the clients and from the persons.
Okay.
Just a question.
Okay.
If I may, just a question for Maria. Do you invest only in the training of the lawyers who are with the legal aid board, or also with the one, because with the mixed system you also pay to others as well? This 100,000 euro, it is only for the training of your lawyers, right?
Yes.
I mean, since we are running out of the time, I have two questions left to all participants. So if you could comment briefly, how does it really look in your countries? First of all, it's, do you have some kind of coordination body which would consist of the, I know that from your presentations you did not mention, so I assume that perhaps not, but I think that it's still very important that where the representatives of the bar, Ministry of Justice, Legal Aid Service gather regularly on a regular basis, share the information about, so to say, deficiencies of the system or some kind of challenges that are faced, including of course, the legal aid quality issues, but not only. Because I can say that perhaps you heard from yesterday's presentation that under the Lithuanian law there is this, so to say, the coordination council established, where the idea behind this body was that to ensure this, I don't know whether it functions now, but at least you will be, perhaps you will be able to comment on this a bit, but it's set in the law that representatives of the Parliamentary Committee on Law and representative of Parliamentary Committee on Human Rights, representatives of Lithuanian Municipalities Association, the legal aid services, and also the secondary legal aid offices that should gather on a regular basis, share the information, and so to say, monitor the system and see deficiencies if there are some policy issues that would be debated. And this is the body that we have under our legislation. Perhaps a representative of the Ministry of Justice will be able to comment a bit on this, whether it's efficient or not, or just perhaps already there. But it's, yeah, it would be interesting to hear how does it really function in your countries. And the second question that I have is, we touch upon a bit this legal aid funding issue, but I know that it's very difficult to compare the situations in different countries, but still, I mean, in terms of the tendency or trend, is it the funding increasing, decreasing, or it's on the same level? Because this is very important just to see how the government uses this legal aid system. So, who is the volunteer to comment on this? Yeah.
Special organization, coordination, organization in Latvia we don't have.
Really?
But we have regular meeting with Bar Association and Ministry of Justice. In these meetings we discuss actual problems, maybe also some issues to improve the law. Now in Ministry of Justice is working group to improve law of advocacy and how to put there in this law criteria of quality. This is our actual work now.
And in terms of funding?
But funding, yes, this is a problem for us. We have some steps by step per year to increase our funding. But in civil matters, we want to these steps more larger than our government.
How big is it now? How big is the funding?
Now it is approximately 3 million.
Okay. Yes, please. You have to run, yeah?
I'm very sorry, it's not your questions, but the flight that is leaving, so I'm leaving. But very shortly about the funding. I think it's our business to take care of the funding within the government. So it's our business to convince the Ministry of Finance of the rule of law state and the justice and what it requires, and that we are working quite hard on that. And at the moment, we have, for a reason, let's look 3, 4, 5 years back, I think we managed quite well. We've got more funding because of the asylum seekers, so it was clearly that there were more cases coming in, but we did get more money for that purpose. And now for the next years we get more funding, but it's because we are taking on new tasks, so debt erasing will be part of our scheme, and so there are clear reasons for it, but I know that in many countries there are quite hard cuts, and I'm very happy that we've been able to keep up the level. And yeah, we also go now for the Ministry of Finance to propose a raise for the hourly fee, but we'll see what happens. It's just a suggestion. But thank you very much for everybody, and this is slightly an interesting discussion. Shame to leave in the
Thank
middle.
you very much, and we have a good trip back, and I hope that we'll see each other somewhere in summer. Okay, could we ask other? You don't know.
Maybe I can respond to your questions about conflict with the bar on the highest level. We meet the board of the bar association 4 times a year. On the professional level, it's more, much more. And also we try to have with the local at least 1 or 2 times a year. And in the bigger regions, it's much more than that. When necessary.
And those meetings, are they somehow formalized? There are some kind of minutes taken, decision made, and then somebody is in charge of ensuring that certain decisions made are implemented? I mean, I know that there is no need to make a lot of bureaucracy about this, but sometimes just to ensure the administrative continuity.
Not bureaucratic at all, but it's an exchange of usual policies, try to make agreements, that's on the national level. And with the local things, most contacts are concerning individual lawyers, who need attention.
That's the time when you complain about them, yeah, and bring all the complaints. And in terms of the funding, is it stable?
We have an open-ended budget, so all bills and are guaranteed, and all applications are guaranteed. But also this open-ended budget, it has limits. So if you want to talk about a higher remunerations, then there's no money for this the Ministry of Justice. So then the answer is, can we make the system more economic and provide better quality? And help clients better. So what I thought about that, the government is not going to spend more money on legal aid in the future. It should be less than it is. That's the situation.
Shortly, legal aid budget is a big issue in France. We had a major strike last year, a lawyers' strike, because the government wanted to tax lawyers. Because, very briefly, we spend 500 million euros a year. At the beginning of each year, government give the 500 million to local boards, and local boards make interest with this sum. So the French government wanted to tax this interest. We had a major strike of lawyers, and so legal aid budget increases to satisfy legal aid providers. But I'm not sure that we could continue a lot like this, because every year the threshold for being granted legal aid is reviewed, and when you increase this threshold of 15 euros, this is something like 100 people that can be granted with legal aid, 100,000 more people which can be granted with legal aid.
And my second question about some kind of regular coordination.
We have a national council for legal aid with representative of Ministry of Justice and lawyers. We are talking a lot about quantitative data and only a few about qualitative matter.
Regarding the coordination, the two main stakeholders, as we understand from the previous, are the bar and the government, and they're both represented in the composition of the National Legal Aid Bureau in Bulgaria, because it has 5 members. 2 of them are appointed by the government, normally by proposition of the Ministry of Justice, and 3 of them are elected by the Supreme Bar Council. So, as you see, the representatives of the Bar Council actually have the majority in the management of the Legal Aid Bureau, which explains why it is so easy to split the responsibility for the quality control, because it pretty much remains with the participation of the government, but within the reach of the Bar Council. Regarding the budget, you know that there is a good comparative data from previous years from the CPESH reports of the Council of Europe. Bulgaria there would be in the middle of the table, but of course comparison is very difficult, because in Bulgaria we account as legal aid budget only the fees we give to the lawyers. At the same time, poor people, indigenous people are also exempt for paying court taxes, and this is not included in the overall budget for the legal aid. So it is not a reasonable estimate of what we really spend for legal aid. But in terms of the money that are paid for individual lawyers, the budget is being stagnating since 2008, which is pretty much a good news actually, because in other countries it was decreased. And it is also quite enough to cover the current needs, because we have a quite significant drop in the overall number of criminal cases, and the ex officio representation in criminal cases takes about 70% of the overall budget of the legal aid board. So if we have a decrease of the criminal cases, they are more comfortable with the money they have. On the table currently there is a proposal to increase the margins of payment for individual lawyers that, like in most European countries, are lower than what the lawyers would take normally in the market sphere. I don't know how it is developed, how it is going to develop. It is a question to be decided by the government, because it's up to the government to decide. However, I would warn very strongly against associating closely the question for the money that the lawyers get and the quality of the legal aid. Because in a way it leaves the impression that if the lawyer is paid less working under the legal aid, he or she provides worse quality of service. we were interviewing a number of judges, and all of them are saying one and same thing. They say, because we have the mixed system, they say if you have a lawyer who is a good contractual lawyer, it really does not make sense who is paying. It is going to be a good lawyer, even if it is the legal aid bureau that is paying for him, and we are going to be happy with his service. At the same time, if we have a bad contractual lawyer that is contracted on the free market by the client, he might be also bad with the legal aid money. So linking the two questions closely, in a way, leads to the idea that the legal aid funded by the state and paid less than the market value is in somehow of a lesser quality. But I have never seen empirical evidence for this, for sustaining this idea, even though I know that it's quite widespread. Thank you.
Thank you. Our Ministry of Justice perhaps will be able to comment a bit on the Coordination Council.
Yes, it's an important body, and it functions, and we meet, we try to meet at least twice a year. Every draft law on legal aid has to be, first of all, has to be discussed in the Coordination Council. And not only the representatives of the Ministry of Justice, Lithuanian Bar, but also the member of the Ministry of Finance, the representative of the judges and the prosecutors, NGOs also participate in our council. And the ideas expressed there are really important, and well, if anything arises there, it's an incentive to have a draft law, draft governmental resolution, or any other kind of legal document. Well, it's a place where we discuss issues, where we share opinions, and we try to find some ideas to improve our system. So it is important.
So thank you very much. I see that we are running out of the time, and we need to conclude at least this session, and I think that in 15 minutes the entire conference will be concluded. So thank you very much for your contributions and active participation. I think that all these ideas and experiences and information shared would be of definite value, not only for Lithuania but also for all the not only for the member countries of this project, but also for those countries who are here, because I think that this is exactly the good opportunity for all of us to share and compare the differences that we have in our systems, and see how, in our national jurisdictions, what kind of changes could be made, because in my view, this is the continuous process. You will never stop. There will be always challenges, new challenges, old challenges, but there will be always questions that will have to be raised, answered, and proper, adequate, timed, and effective solutions made. So I think that this event will definitely contribute to this, and thank you very much once again.